for us on the Washington Journal this morning. We now send you over to live coverage of the D.C. Circuit Court of Appeals.
Occupied in adding these unconstitutional burdens of process to punish Michael Flynn, Judge Sullivan discarded any semblance of the unbiased, impartial adjudicator this court extolled in al-Nashiri, the 2019 chapter of that case saga, as the cornerstone of any system of justice worth the label. 4 rulings are required to conclude this novel Article III excess. Judge Sullivan's petition for rehearing must be flatly denied, with clear Ligon-like language that a judge has no injury and no standing to seek relief in this court of this court's rulings. Second, because Judge Sullivan has so invested himself in his own prosecution of General Flynn, al-Nashiri mandates his disqualification for the now glaring appearance of bias to millions of citizens. Third, Cheney, Sinning, Smith, and Bond require mandamus issue to vacate the unconstitutional appointment of Mr. Gleason for intrusion into the sole Article II functions of the executive branch. And fourth, mandamus must issue to compel the district court to grant the dismissal as a matter of law. Only the Department of Justice can decide the public interest and myriad factors inherent in pursuing a prosecution. This is not an ordinary motion on which there can be factual development or debate. This is a Rule 48A case dispositive motion as to which the executive branch has sole discretion and determinative authority. The government has dropped the case, and every 48A decision in the country requires this motion be granted.
Thank you, Ms. Powell. I'll begin the questioning. And can I ask you the following question? And assume with me that I'm focused primarily on your request to require the district court to grant the 48A motion, and just put aside for one moment the other forms of relief that you're requesting. I'm focused on the one that the panel decided the case on, which is the requiring the district court to grant the motion for dismissal under Rule 48A. And you agree that you're entitled to mandamus as to that form of relief only if there's no other adequate means to attain the relief?
Yes, Your Honor, and there is no other adequate means to attain the relief because of the usurpation of power and intrusion into the Article II branch by the process he's suggested, and the fact that there's no discretion involved in the district court on the district court's part in addressing a 48A motion.
But are you aware of any other case in which mandamus has been granted to compel a district court to decide a pending motion in a particular way, either by granting or denying it, before the district court itself has decided whether it's going to grant or deny the motion?
Well, now that we have Fokker Services, which of course you know as you wrote it, that with the law is clear that this motion has to be granted. Every 48A motion in the history of the country has ultimately been granted. He could have had a hearing. He has had ample time that he could have had a counsel appear in front of him, but there's nothing.
I'm not even focused. If I can just stop you for 1 second, I'm not even focused on Rule 48A motions as such. And I take your point about Fokker, and in fact, for purposes of this question, I'll assume, and it's just for purposes of this question, I'll assume that everything you've said about the Fokker decision all along is correct, and I'll assume further that the en banc court agrees with Fokker, even though Fokker was a panel decision. But I'm focused on the prong of mandamus that deals with other adequate means. And whatever you might think about the clarity of Fokker, that's going to be true of all kinds of decisions that are on the books. And I'm not even focused exclusively on 48A motions. I'm asking just for any kind of motion pending before a district court. Are you aware of any situation in which a district court has been compelled under mandamus to grant or deny the motion before the district court itself has decided whether to grant or deny the motion?
No, sir, because I don't know of any other case where a district court has set about the process that this district court did that went outside the boundaries of Article III from its very inception. From the minute he requested amicus, which is not provided for in the rules of the court at all in a criminal district court case.
If the district court grants the motion, then that would be adequate alternate means, would it not?
Well, no, sir, because the process here is the problem. The process is what violates both Article 3 and Article 2. He could have granted or denied the motion months ago, 3 months ago to be precise. But instead, we've had the unconstitutional burden that Cheney talks about being imposed on us by the process he created that he has absolutely no authority to create. All he is entitled to do, even if he'd done it timely, would be to review this motion on its face and grant it. Okay. There is no precedent whatsoever for denying it.
Thank you, Ms. Powell. I'll let my colleagues answer questions and follow up in the follow-up round with anything more. I appreciate your answers.
Thank you.
Judge Henderson?
No questions, thanks.
Thank you. Judge Rogers?
I'll follow up briefly. To what extent do you understand Fokker to the extent you rely on it, given the Chief Judge's assumptions and the panel opinion? Was Fokker not a case where mandamus was granted after the district court had ruled?
Yes, mandamus was granted in Fokker after the district court had ruled on the deferred prosecution agreement. And because we have Fokker now, we know that Judge Sullivan has to grant this motion. And because he went through the guardrails of any bridge of Article 3 construction whatsoever, he has to be reined back in. And at a very minimum, mandamus must be issued to vacate the appointment of Mr. Gleason as an amicus. And there are no circumstances now under which Judge Sullivan can continue on this case because his bias demands his disqualification. Just the very appearance of bias is enough to demand his disqualification. And here we have a long history of decisions made on the basis of extrajudicial contact and the blistering op-ed in the Washington Post that led him to choose the amicus he appointed. He even waived the requirement of local counsel for him. He's added additional perjury and contempt charges over General Flynn's head. The perjury is now teed up for additional punishment at the recommendation of the amicus. Judge Sullivan failed to follow this court's mandamus itself for 15 days and then took the unprecedented step of seeking rehearing by filing his own petition for rehearing in this court when he has absolutely no standing to do so. Taking on the mantle of an active litigant has to disqualify him from proceeding any further in this case if all the things that happened before were not already sufficient.
Now, in Will, the Supreme Court stated that it had never approved the use of a writ to review an interlocutory procedural order in a criminal case, which did not have the effect of a dismissal. It acknowledged that it wasn't saying mandamus could never be used, but it noted that mandamus had been invoked successfully where the action of the trial court totally deprived the government of its right to initiate a prosecution, or where the court overreached its judicial power to deny the government the rightful fruit of a valid conviction. Neither of these situations apply here. So why is it appropriate to use mandamus to review the procedural steps the district court took in connection with consideration of the government's motion?
Your Honor, the usurpation of power does apply here. That's exactly what Judge Sullivan did when he appointed Mr. Gleason in the stead of the government as soon as the government moved to dismiss the prosecution. There's no authority whatsoever for a judge to pile on and add on his own prosecutor against a criminal defendant. The fact that this is a Rule 48A motion as opposed to the Bill of Particulars issue and will makes all the difference in the world, because only the government can decide when to stop a prosecution. And that's the authority he is intruding on. He's not entitled to ask any questions about that whatsoever when more than a mere conclusory statement has been made. And in this case, we have a 100-page motion to dismiss supported by stunning exculpatory evidence that was suppressed for 3 years or more. This is an extraordinary case. The process he's created is beyond the pale, as Judge Ginsburg would say in Sinning Smith. And if nothing other than Sinning Smith requires that it be ended and mandamus issue.
Thank you, Ms. Powell. I want to make sure that Judge Rogers has no further questions before proceeding.
Thank you, Judge.
Judge Tatel.
Ms. Powell, just a quick question. You argue that Judge Sullivan has no standing to file an en-banc petition. Does that make any difference if we en-bank this case sua sponte, that is, on our own?
Well, according to the court's order, it considered his petition for...
But that doesn't, of course we considered his petition. We consider all petitions, but I don't see anything in the order that says we granted it or denied it. If we...
Well,
my question, though, is, if we, in fact, en-bank the case sua sponte, then does it really make any difference whether Judge Sullivan is a party or has standing?
It does in terms of the disqualification issue, Your Honor, because it shows...
I'm asking you about our ability to hear the case en-banc.
The court can always take a case sua sponte.
Thank you. Thank you. I have no further questions.
Thank you. Judge Garland?
Yes, thank you. So imagine the Supreme Court has decided an issue that is in the district court squarely, and without any doubts, completely on all fours. And the person who moves for summary judgment based on that case says, I don't have to wait. You have to decide this before you decide whether or not it applies. And if you don't decide in advance of the motion, I'm going to mandamus you. Why isn't that the same as this case? Well, first of all, I assume you agree that even if the Supreme Court had decided an issue that's now in the district court directly on point, that would not be enough to mandamus the judge before the judge decides. You agree with that?
No, it would not, Your Honor, because it wouldn't be a 48A situation that involved the core powers of the executive branch.
Well, what if it was a separation of powers case about the core powers of the executive branch, and the Supreme Court had decided that the executive branch has this power? The plaintiffs were claiming that it doesn't, and the judge has not made up its mind yet. Wouldn't you agree that still the district court has to make the decision before you can appeal, or before you can seek mandamus, or before you can do anything else?
Well, he's effectively made a decision here. He denied 2 motions opposing any amicus at all and denied our request that the motion to dismiss be granted before he even appointed Mr. Gleason, and then started the whole process that intrudes into the Article 2 executive power that he simply cannot do.
Do you disagree with Judge Rao's statement that the district court currently presiding over the case has yet to decide the government's motion?
Yes, I do at this point disagree with that, because I went back and looked at the record again and realized we had filed our request for him to grant that and oppose the amicus twice before he even appointed Mr. Gleason.
That's on the amicus question. What about the dismissal of the case question?
We in that motion at around docket 200, I think, we requested again the dismissal be granted.
I see. So the panel just got that wrong.
Well, it was my failure to point out to the panel that that motion had previously been granted, but we corrected that in our opposition to his petition for rehearing. The thing that makes this so different from the summary judgment context or anything like that is it's a criminal case in which the defendant, all the constitutional rights are supposed to benefit the defendant.
We have lots of cases, don't we, where we have reversed a district court for clear or plain error in a criminal case, and yet there was no ability of that defendant to do anything other than appeal the conviction. They could not mandamus the court. Imagine that the Supreme Court had decided a Fourth Amendment case and clearly applicable to that particular defendant in that defendant's favor. And then the district court ruled the other way. The defendant would still have to appeal, even though the defendant's liberty was restricted and a conviction stood. Isn't that right? That's the normal way criminal cases go, isn't it?
That's the normal way criminal cases go when they're dealing with solely legal issues and the government hasn't walked in and said, I quit, when the government is the only entity that can pursue a prosecution.
So it's not just a question of the clarity of the law at the time.
No, it's not just a question of the clarity of the law at the time. It's a function of the sole authority of the executive branch being the one to prosecute. All the discretion is vested in it to weigh all the factors that go into dropping a prosecution. And the court can't continue a prosecution on its own, which is essentially what Judge Sullivan has tried to do here and has done very effectively for 3 months.
So if all that the district court had done was ask Mr. Flynn and the government to brief and orally argue the scope of Rule 48 and any separation of power arguments, and permitted amicus but did not appoint amicus, you would not have the argument. Is that right?
No, I think we still would. I think that's far more procedure and process than is allowed by precedent on any 48A motion in the history of the country.
Okay. Thank you very much.
Thank you. Judge Griffith?
Thank you, Ms. Powell. As I see it, the question before us is not whether the district court must grant the 48A motion. The question is whether the district court may appoint an amicus and hold a hearing before deciding that motion. Now, in your view, what is it in Rule 48A itself or in our cases that prevents the district court from conducting a hearing before deciding the motion?
Well, the Supreme Court and this court has said that the court has no substantial role whatsoever in ruling on a 48A motion. The leave of court provision is not a license for him to investigate behind the stated reasons the government has for dismissing the case.
What is the role of the leave of court language then? From your comments today, you make it sound as if it's ministerial.
It almost is ministerial. It allows
what is almost is ministerial mean? Is it ministerial or not? Yes or no?
It's pretty ministerial.
Well, that's not Ms. Powell. That's not helpful. It's not ministerial. You know it's not. The case law doesn't say it's ministerial.
Well, no, Rinaldi does.
So it's not ministerial. So that means that the judge has to do some thinking about it, right? The judge just is not simply a rubber stamp. I mean, the language of the rule itself and the history of the rule shows the judge is not a rubber stamp. So aren't we just arguing about what the judge must do to educate himself or herself to be able to rule on the motion? And I take it your point is that the rule itself forbids the conducting of a hearing before the motion. Is that your position?
No, sir. It's the Constitution and the Supreme Court's decision in Rinaldi and this court's decision in Sobel.
That prevents any hearing before the motion?
It prevents any inquiry behind the government's stated reasons for the motion. It prevents any substitution of Judge Sullivan's opinion of what type of government.
What type of hearing is permissible, Ms. Powell?
He could have called the parties in and say, does the government move to dismiss? And the government says yes. And he could have said, well, is this Brady material? And they could have said yes or no, or Giglio, like he pushed them a bit on the Stevens case. But to have any evidence, any contrary testimony, to ask the, quote, plausible questions he had that he's mentioned in his brief that he wants to ask, none of that is permissible whatsoever, because Rinaldi makes it clear that the leave of court provision is only to protect the defendant from being harassed by the government. So the only discretion he has is whether to make sure it is with prejudice, as Judge Sullivan himself did in his decision in the Pitts case. The government wanted to dismiss it without prejudice, and he said, no, it has to be with prejudice. And that's what he did in the Stevens case, too, on just a 2-page motion to dismiss filed by the government.
Ms. Powell, you've stated in oral argument today that you believe that you have a very strong case before the district court on Rule 48A, right?
It has to be dismissed. Yes.
Yeah, you have a strong case. In that case, why mandamus? Why not simply appeal if Judge Sullivan does not grant the motion to dismiss under Rule 48A? Why not simply appeal that to us?
Because the process he has started and intends to pursue violates the Article 2 powers of the executive branch, and Bond entitles General Flynn to stand on those constitutional principles of separation of powers and allege the harm that also occurs to him by the violation of his constitutional rights. And as I think it was In re Peru or Ex parte Peru said, to a prompt termination of these proceedings instead of a trial upon a trial of the government's decision to dismiss, which he has no discretion or authority to inquire behind whatsoever. Every case in this country that has ever addressed a Rule 48A motion has required it be granted. Every one.
And you don't think that's what will happen on this one? We don't know. We don't know, do we? I mean, the fact is we don't know. Judge Sullivan hasn't ruled yet.
Proposed is unconstitutional. We know that the process he's proposed tramples all over the executive branch's independent authority to do it, as well as what went into its decision making. Nothing about what he has done since he got the motion to dismiss it has been done in any other case we could find. Not one single step of the procedure. And to add on someone to prosecute the defendant, as Mr. Gleason wants to do, when
I don't understand your statement. I mean, the appointment of amicus before a court to argue a view that's not going to be presented by the parties, that's common.
Not in court in criminal cases, Your Honor. There's no rule provision for it. It violates Hollingsworth versus Perry. He can't just go out on his own and do this, and it steps all over the Article 2 executive branch authority.
Okay, thank
There's
you.
nothing fair about aligning people against a defendant in a criminal case as if there weren't enough already.
Thank you, Ms. Powell.
Thank you. Thank you.
Judge Millett.
Yes, good morning, Ms. Powell.
Good morning.
Just a few questions for you. Where in the district court did you raise the separation of power arguments?
It was a motion we filed in opposition. Amicus started because of an email sent to Chambers by the Robbins-Russell firm on behalf of the self-described Watergate prosecutors, in which they copied me, evidencing their intent to seek leave.
I'm aware of that. And so you say your opposition to that amicus filing, which was before the appointment of Mr. Gleason and before the briefing schedule was issued and this whole process for a hearing was your opposition to orders that the district court issued later?
Yes, and we requested.
Okay, okay. Just to be clear, so your answer is that
I think it's around docket
before
number 2.
The district court even did it. Yeah, no, I know that's your opposition to the Watergate prosecutors, but there was no Gleason, no appointment yet of Mr. Gleason, correct?
No, he did not enter that order until after we filed the petition for mandamus, but he said he was going to.
And after the district court issued that order appointing Mr. Gleason, where's your objection? Raising the separation of powers concerns or any concerns? Where's your objection?
Well, the separation of powers objection was already on file with respect to
No, that was with a different amicus. Where is, because the argument here has not mentioned once the brief about the Watergate prosecutors. It's all about Mr. Gleason's appointment to take over the prosecution, to inquire and scrutinize the government's, Mr. Gleason, to be clear, is arguing for this, to scrutinize the governmental motives. Where is your opposition to the appointment of Mr. Gleason from the district court?
Our original opposition, I believe,
Before
is
he was appointed.
docket numbers 201 and 203.
Okay, so
and
after
that
he was appointed,
opposed the appointment of any amicus
Sorry, this
for
works a
the
lot
same
better. One
reason.
person. This works a lot better if you'll just let me get my questions, because sometimes I just need a quick yes or no. So I'm just clarifying. You didn't do any made no opposition, no objection to the appointment of Mr. Gleason. You're just referring back to arguments you'd made to the Watergate amicus, sui sponte, moving for amicus in the case. And in his minute order on May 19th, setting out this little briefing schedule and amicus, the district court said the following schedule shall govern the proceedings subject to a motion for reconsideration. Did you ever file a motion for reconsideration?
No, Your Honor, we had already filed a petition for writ of mandamus because that's what exists. That's the remedy for an usurpation of power.
Okay, I thought the mandamus was filed after that. Our docket shows 521 and this order was issued 519. Am I wrong?
We filed the mandamus on, I think there's a mistake in the order of the docket entry. That's when Judge Sullivan was asked to respond to it, but it was filed on the 19th.
Motion for reconsideration. Okay.
No, that's the purpose of mandamus.
Yeah, okay, sure. You mentioned that in your response to one of my colleagues that the district court could have brought the government and all the attorneys in, obviously, for a hearing and could have pushed them a bit, I think was your phraseology, as in the Stevens case. Can you elaborate on how much pushing the district court is allowed to do?
Not very much. He cannot inquire into the deliberation or the decision making.
What pushing in the Stevens case was okay? Tell me exactly what pushing was okay.
He asked the government if the material that had been withheld from Senator Stevens was Brady material, and they kind of they were a little wishy-washy on that, and then they admitted it was Giglio, and that was the virtual extent of it.
Okay. In this case, a large portion of the government's explanation for its motion to dismiss is the discovery of new material that would qualify as Brady material, correct?
That's correct.
Okay. Another question is you've mentioned that courts cannot appoint an amicus to argue against a defendant's interest in a case in which the government has sided with the defendant. Correct? Or do you say there's just too much, right? Once the government's agreed with the defendant, you can't appoint an amicus.
At the district court level, the rules have no provision for the appointment of amicus in a criminal case.
Is there a rule against it?
No, but by the virtue of the fact there is a civil rule in the district court and there's not one in the criminal court. Is there a
Supreme Court rule that says they can appoint amici in criminal cases to argue against the interests of a criminal defendant when the government has aligned with it?
The Supreme Court and appellate courts routinely appoint amici for various.
Is there a rule in the Supreme Court saying that they can do that, and including, as you're talking about, in a criminal case to align against a criminal defendant? Or is there a rule saying they can or can't?
I do not know.
Okay, but they have done. The Supreme Court's done it.
The Supreme Court appoints amici whenever it wants to.
Right. Okay. Just trying to clarify that. One last quick question for you. You talked about the role of a court under 48A. The one thing it can do is obviously prevent harassment of a defendant. If this had been a motion to dismiss without prejudice or something, the district court could have insisted that it be with prejudice, or at least examine that question with the government.
Correct. That's Rinaldi and Judge Sullivan's decision.
I think you agreed with Judge. I think it was Judge Griffith. This is not a purely ministerial process. Can courts use 48A to protect their own processes, to ensure that prosecutors are not abusing and manipulating the court process?
No, Your Honor, it cannot. 48A is not for that purpose.
Okay. All right. Thank you. I'm finished.
Thank you. Judge Pillard?
Good morning, Ms. Powell.
Morning.
One decision that seems, I think it's the only decision that I've been able to find that deals with the question of whether mandamus is appropriate before a district judge has even had an opportunity to rule on a Rule 48 motion is the Third Circuit's decision in Ray Richards. Judge Edward Becker's opinion, and there the Third Circuit denied mandamus because the trial court had not even had a hearing on the Rule 48A motion. We haven't decided this issue in our circuit, but Richard suggests that there is no clear and indisputable right against briefing and argument on a Rule 48A motion.
Well, it's already been briefed. I'm sorry, Your Honor, go ahead.
Right, you are opposing the briefing, adversary briefing and argument on the motion. That's why you sought mandamus, am I right?
Yeah, well, yes, that's because there is no adversary, because the parties have consented. General Flynn and the government have agreed to the motion to dismiss. There's no longer a case or controversy for the district court to adjudicate. And 48A, and even the in Ray Richards case, which is a 20-year-old case out of the Third Circuit from a territorial court in the Virgin Islands, in which the government just made a mere statement of it's in the interest of justice, and the court said we need a little more sunlight on the reasons for that. That's
right. In Richards, you do just try to distinguish Richards on the ground that there was only a conclusory interest in footnote 3 of your panel briefing, but in Richards, the prosecution's joint motion to dismiss had supporting affidavits from potential witnesses saying they wouldn't testify. The court there was entitled to read the briefs, listen to argument, consider contrary arguments before granting leave. Do you disagree with that? Do you think that was wrongly decided, that case?
Given the particular circumstances of that case and a key witness who recanted, if I recall, in a sexual misconduct case that was extremely high profile, now 20 years ago, there's been a substantial development in the law.
Do you disagree with Richards on, Ms. Powell, do you disagree with Richards on its own terms in that case? Is the only distinction that you're trying to draw the appointment of amicus? That there, it was premature, the Third Circuit held it was premature, mandamus was inappropriate because the court could listen to argument and look at the motion and the supporting affidavits and consider whether to grant leave. You don't have any quibble with that, do you?
As of 20 years ago, no. As of now, yes.
So under the law as it currently stands, you think that they should have granted mandamus in Richards? And that's why?
If Richards were now, then yes. If
why?
Richards were now, then yes, I would say that because there is a 100-page motion to dismiss here with 80 pages of exculpatory evidence that wasn't produced to the defendant, the fact that the Brady evidence was suppressed alone is sufficient to vacate the guilty plea. We also have other motions on file with multiple reasons why the plea is not valid. And the bottom line is that a 48A motion leaves no discretion in the district court, even more than an ex parte U.S. The court said that the discretion to grant or issue a bond or a bench warrant is not the discretion to deny it.
But we don't know whether this district judge was going to exercise his discretion to grant or deny this motion. We would assume, given the precedent that we've read and that you've read, that he would grant it. That would be the assumption, right?
We know that the process he has established violates.
So it's the process. It's the process that you're objecting to because we don't have a merits ruling, right?
Well, you have a
process that you're
ruling on appointing the amicus that would have to be vacated at a minimum. And then it would have to be remanded to a different district judge because of all of his actions that now amount to the egregious appearance of bias that prohibit him from on this case any further.
So Judge Sullivan showed bias by appointing an amicus, but Gleason wasn't being chosen as the judge. He was invited to argue one side in an adversary system. And the adversary system is so that we get the law right. It's the core of any judge's job to assess cases in view of the strongest arguments that can be made on both sides. And your position is No, he can't hear both sides on the law. He has to drop the case like a hot potato without adversary briefing and argument. That's your position.
There is no provision for amicus in a criminal case in the federal district court, and certainly not to take the position of the government when it has decided to drop the case. When the government signs off, the case is over. The Article 3 branch cannot make the Article 3 branch prosecute a case.
So I think that your position is, correct me if I'm wrong, that to the extent that Rule 48A requires leave of court where anything other than the defendant's interest in a with prejudice dismissal is at stake, that every other application of the leave of court requirement is unconstitutional under separation of powers. Is that a fair way to put your position?
Yes.
Okay. No further questions.
It is a very limited
Thank you. Thank you.
review.
Judge Wilkins?
Yes, good morning, Ms. Powell.
Good morning.
I have a hypothetical. So suppose in the future, in a different administration, you had a 48A motion that was filed and that was unopposed, and the prosecution said, you know, it's because of this exculpatory evidence that we're moving to dismiss. And a Catholic University law professor asks to be appointed amicus because a group of nuns and bishops happened to witness the prosecutor taking a briefcase full of cash from the defendant in the case, and they made a videotape using their smartphones of the transaction, and they presented that to him along with sworn declarations. And so he wants to file an amicus brief and attach that evidence. Is that improper?
Well, that would certainly be improper behavior by the prosecutor and worthy of prosecution itself by the Department of Justice.
Is appointment of amicus, that professor as amicus, improper?
I believe it would be if the government had already filed a 48A motion and had decided through its appropriate channels to drop the case. That's a decision that has to go all the way up to the Attorney General and the Solicitor General, I believe, for a 48A motion to be filed. And whatever the considerations that were that go into that belong to the Department of Justice, not the Article 3 judiciary, although it could certainly make a criminal referral and should.
So if the district judge said, okay, I'm not going to appoint amicus because the defendant has objected to that, but I want to hold a hearing and I'm going to ask that those witnesses come to the hearing and bring their video footage of this alleged bribe, the district judge, because it's an unopposed 48A motion, cannot hold that hearing?
He cannot go behind the prosecutor's decisions to dismiss a case. And he certainly can't on the facts of this case. I mean, one of the reasons I think—
I'm asking you about my hypothetical. That would be improper for the district judge to hold a hearing under the facts of my hypothetical.
I believe under the facts of your hypothetical, what the district judge would have to do is refer the matter to the Department of Justice for prosecution.
All right, I have no further questions. Thank you.
Thank you. Judge Rao?
Thank you. Good morning, Ms. Powell. So I guess one of the questions that my colleagues seem to be focusing on, I want to maybe just hear from you again on this, is, you know, what is the most that a district court judge can do when considering leave of court under Rule 48? It seems that you think he can hold a hearing. Is there anything else that he can do?
Well, according to all the existing authority, it's described his role as extremely limited, virtually no role. there's just not much he can do in the face of the government's decision not to prosecute a case, because the law is clear that it's up to them to weigh all the myriad factors that go into deciding whether something should be prosecuted, including the allocation of existing resources. I mean, it can be something as simple as, in fact, in one of the cases, just the fact they didn't agree with the sentence was grounds enough to grant a mandamus. I think that was the Ham case, the en banc Fifth Circuit case. So it's up to the prosecutor to weigh all the factors that go into deciding whether a case should continue or be prosecuted at all. And once it makes that decision, the Article III branch is simply to protect the defendant from being harassed further.
Okay, so to what extent would reassignment, if the court were not to grant a writ of mandamus, to what extent would reassignment to a different judge cure the problems that you've identified?
Well, that would certainly cure the bias and recusal / disqualification problem. And it would also vacate the appointment of the amicus, according to this court's decision in al-Nashiri, because of the fact that the decision had been made by a judge who was disqualified, and that would have to be dropped, or it should probably be made clear, though, that the amicus appointment has to be vacated, because that's a severe Article II intrusion and also tramples on the defendant's rights to not have the world piling on against him when the government's decided to drop the case. That would go a long way toward solving the problem.
Mm-hmm. Okay, thank you. No further questions.
Thank you. Ms. Powell, I just have one question for you as a follow-up. Suppose again that we're dealing only with the 48A question, and the issue is whether mandamus should be granted to require the district judge to grant the 48A motion. And suppose also, just for purposes of argument, that I agree with everything you have said about what Fokker means. If the district judge receives the 48A motion filed by the government requesting dismissal, and the district judge says, I want to schedule a hearing for 2 weeks, I just want to make sure I understand the government's reasons for requesting a dismissal. At that point, would you be entitled to mandamus relief because the district judge has scheduled a hearing for the stated purpose of understanding the government's reasons for requesting a dismissal?
No, sir.
Okay. Thank you. Judge Henderson?
Yes, I'd like to just ask you a rhetorical question. Are you familiar with, I believe it was Ezra Pound, who said some circumstantial evidence is so strong as when you find a fish in the milk? Do you think that applies to this case?
I think it might, Your Honor.
Thank you. That's all I have.
Thank you.
Nope.
Judge Rogers?
No questions.
Thank you. Judge Tatel?
No questions.
Thank you. Judge Garland?
Yes, thank you. Good morning again, Ms. Powell. One thing I want to do is clarify a record point. I had asked you whether the district court had actually decided against General Flynn's motion to dismiss, and you said that the panel had been in error, not the panel's fault, but your own, and that you found that the district court did decide against. I have the docket sheet in front of me. I don't see a ruling on, I assume the motion you're talking about is your docket number 202, but I don't see any denial of that motion. Could you help me with where that is?
He did not enter as docket entry for denying that. It was, let's see. And what's missing as docket entry number 201, we made a sealed filing objecting to the process discussed in the email that was sent to Chambers by the Watergate prosecutors. And then at docket 204, we filed a motion to strike in opposition of notice of intent to file a motion for leave to file amicus brief on the record with some modifications to alleviate the problem that was in the sealed filing. And then he denied, and it was in that motion that we also requested that the motion to dismiss be granted. Well, he denied both those, the sealed and the 204, the next morning.
So you're saying that the 204 included a motion to dismiss. His ruling on 204 says he denied the motion to strike in opposition to notice of intent to file motion for leave to file amicus.
204 included a request at the end of the motion that he grant the government's motion to dismiss.
He denied this motion as moot because he had denied the additional amicus. Isn't that right? Are there some words where he said, I denied the motion to dismiss? I just don't find that.
No, I'm sorry. No, there's not a separate order in which he denies the motion to dismiss. No, sir.
All right. Two other quick questions.
I misspoke or was less than clear. If I implied that, I apologize.
I might have misheard, so in which case I would apologize. On the bias question, so the panel majority found that the district court's conduct did not indicate a clear inability to decide this case fairly. Do you want us to reverse the district court, the panel's finding on bias at that point, or is your claim only arises out of the filing of the petition for rehearing on the bias claim? Our request now goes back and includes the comments that the district judge made at sentencing, or what was supposed to have been the sentencing, that indicate bias, but also carries forward more into the facts that the panel did not consider. That was what they focused on, the statements that were made in the course of the litigation, which, as we know, are usually excused. But in this case, there's been a lot more since then, and that includes receiving the email from the Watergate prosecutors and agreeing to appoint the amicus at their suggestion, his inexorable determination to go forward with these intrusive proceedings, including denying our motions, objecting to any amicus, and raising the separation of powers issue. Okay, hold for just 1 minute. I'm not clear. Are you saying that you didn't argue these points to the panel and therefore they didn't consider it, or that these events occurred after the panel concluded that there was not the kind of bias that would disqualify a judge? Which is it? I think it may be a little bit of both. The panel definitely considered these statements made at sentencing. It's unclear to what extent they considered any other factor, because the way the opinion reads. Did you argue the other factors? I don't believe we actually even had time to argue the disqualification issue itself in the original panel hearing. But the point now is definitely that Judge Sullivan failed to follow this court's mandamus for 15 days and then filed his own unprecedented rehearing petition that reveals he's so invested in this litigation that there are no circumstances under which he can dispel the appearance of bias from that. Okay. He inserted himself as if he were a party. Thank you. Appreciate the answers. Thank you.
Thank you. Thank you. Judge Griffith?
Yeah, Ms. Hall, I just have a question or two. Throughout the argument this morning, you've been stressing that Rule 48A has as its primary purpose the protection of defendants against vexatious prosecutions, and I can understand your emphasis on that. But that's not the sole purpose of 48A, right? And we know something about the history of it. And the history of 48A, as I understand it, but I'm asking you to correct me if I'm wrong, is that it was also created by the Supreme Court to examine cases of favoritism for politically powerful defendants. And that seems to be right in the wheelhouse of what is going on here. Is that not one of the purposes of 48A?
Not according to the Supreme Court. It certainly never addressed that. Rinaldi makes clear that 48A is to protect the defendant from harassment, and there's no other.
There's no question that's one of the purposes of it, but that's not the sole purpose of it, is it?
As best I can tell from the law right now, Your Honor, that's the sole purpose that has been given any definition whatsoever by any of the cases, because they all.
In the history of the, we have a record of the history of the creation of 48A, and I thought that one of the purposes was to allow a district court judge to examine favoritism for politically powerful defendants.
Well, I think
you just disagree with that history?
Well, I mean, the history is whatever the history is, but the courts have not interpreted it that way because, as Judge Posner noted in Ray United States, there's no 48A motion that's been denied.
So just to be clear, have courts rejected that reasoning, or they just haven't addressed it?
To my knowledge, it has not been addressed.
So that's different than rejecting it, right?
Yes.
Okay, thank you very much.
Thank you. Judge Millett?
Yeah, just a couple of questions. Just to follow up on Judge Garland's question about your document 204 filing, the opposition to the Watergate amicus. And you had a proposed order that went with that motion, commonplace. And that proposed order doesn't mention granting the government's motion to dismiss, does it?
No, because there was an order attached to the government's motion that would have.
Okay, I'm just asking about your brief. I'm just asking about arguments you made. So, yeah. And then, of course, there was one attached to the government's motion to dismiss. You just don't even ask for that in the proposed order, that relief in your proposed order. And the document itself only talks about the Watergate brief and specifically says they want to file an uninvited amicus brief on page 2. Is that correct?
I believe that's correct.
Okay. And then I also had a question following up on Judge Wilkins' hypothetical about the nuns, or I guess the nuns or priests that witnessed the bribery. Could the district court, in a case like that, where the government said its motion to dismiss was based on Brady evidence, and then there's information called to the court's attention that it may have been based on bribery, can the district court, when it calls the parties in to discuss the Rule 48A motion, does it have a right to press the government to see if it was lied to?
I think the recourse for the district court in that
I don't want to hear about referring someone for prosecution. I'm asking you a yes or no question. Can the district court ask the government, referencing this information that's come to its attention, whether it was lied to, whether the court was lied to in a filing made with the district court?
Yes, I
would think. Ask yes. All right. That's all my questions. Thank you.
Thank you. Judge Pillard?
Ms. Powell, on the question whether Rule 48A protects anything other than a defendant's interest against harassment, and just probing further on Judge Griffith's question about whether it's actually open what Rule 48A protects, including, for example, the abuse of prosecutorial power to favor defendants that the government wants to protect. The Supreme Court in Rinaldi, and I think the clearest place is footnote 15, cites Amidon and cites Cowan, and really leaves open the question whether Rule 48A sweeps more broadly and whether a court can deny a consented to motion to dismiss if it thought the motion was prompted by considerations clearly contrary to the public interest. And there it's crystal clear that the court means other than the defendant's protection against harassment. So you may be right that there's not a case allowing a court to deny a Rule 48A motion based on these other public interest concerns, but it isn't a clear and indisputable right against such inquiry? Is there, in light of Rinaldi, in light of Amadown, and the references to Cowan? There's not a clear and indisputable right against application of Rule 48A in a circumstance in which the motion to vacate a plea was prompted by improper considerations, bribery, whatever.
Well, there's a clear and indisputable right to the 48A when the government decides to drop the prosecution, because that's the only outcome that can arise from that. Now,
and that's really your constitutional separation of powers argument rather than an interpretation of the intention of Rule 48A.
It is.
Rule 48A itself and its history Rule 48A and its history, under your view, may indeed invite that kind of superintendence by a district court, but it's your view that if it does, unconstitutional.
Exactly.
Is that right?
Yes.
Thank you. No further questions.
Thank you. Judge Wilkins?
Yes, just following up on my earlier hypothetical, just so that we're clear, if in that situation the district judge said, I want to have a hearing on the 48A motion, which is unopposed, and I want to have the nuns and priests testify and view their videotape showing this alleged handing over of cash from the defendant to the prosecutor, you would say that the judge has no authority under Rule 48A to hold a hearing and proceed in that fashion?
I would say he does not have that authority under Rule 48A, that he would need to refer it for prosecution by the Department of Justice.
And you base that on Fokker?
Fokker, separation of powers, Rinaldi, every 48A case that's ever been decided.
Okay, thank you.
Thank you. Judge Rao?
No further questions.
Thank you. Thank you for your argument, Ms. Powell. We'll give you a bit of time for rebuttal. We'll now hear from the Acting Solicitor General on behalf of the United States. Mr. Wall.
Good morning, Your Honor, and may it please the Court. In our constitutional system, a defendant may not be convicted of an ordinary crime without the concurrence of all three branches. When the executive branch no longer wishes to prosecute and the defendant agrees, the criminal case should be at an end. That is why Fokker says at least 7 times that the decision whether to dismiss charges is a core executive duty that is not suited to judicial review. Under Articles 2 and 3 and Fokker, the government's unopposed Rule 48 motion must be granted. If we're clearly right about that, then there's no adequate alternative to mandamus. The district judge's rehearing brief makes clear what will happen next. Amadown's public interest standard remains good law, he says, and assessing whether the motion serves, quote, legitimate prosecutorial interests, end quote, requires a, quote, developed factual record, end quote, based on investigations into, quote, the facts and circumstances, end quote, of the dismissal. The district court thus plans to conduct an intrusive inquiry into the executive's dismissal decision, which will result in every one of the harms detailed in Fokker, regardless of whether the court eventually grants the motion. The district judge says this court should ignore those harms, but the government is a party that filed a brief at the court's invitation urging mandamus. Under Cobell and ExxonMobil, it's the fact and substance of that filing that matter, not its caption. Even apart from the government, under cases like Bond, General Flynn can invoke the separation of powers harms in defense of his own individual liberty. And of course, courts routinely consider third-party interests in assessing equitable relief, so it would be passing strange if this court could not consider the harms to the government a party that expressly supported mandamus. In the end, the criminal charge against petitioner must be dismissed. The only question is how much further a harmful and unnecessary process will be allowed to play out. The answer in our constitutional scheme should be no further. Thank you.
Thank you. Mr. Wall, can I ask you the following question? So in your opening, you focused on the brief that was filed by Judge Sullivan at the mandamus stage before our court. If you take out of the field of vision that brief, then would you still say that based on what you know, mandamus needs to be granted and there's no adequate alternative means for relief with respect to the dismissal of the 48A motion?
I would, Chief Judge Srinivasan, because in some sense, I think the panel briefs were more concerning than the rehearing petition, because in the panel briefs, Judge Sullivan was explicit that he wanted, quote, affidavits and declarations on both Rule 48 and contempt. And so it was
the panel brief, sorry, but that's still post-mandamus petition. I meant to include that, sorry, maybe I wasn't clear. I'm saying if you take out of the field of vision what Judge Sullivan's briefing has said before this court, either at the panel stage or at the en banc stage, would you still say that we know enough such that mandamus should be granted on the theory that there's still no other adequate alternative means?
I would, Your Honor. I want to both answer the question. I don't want to fight the premise too much, but I do think the very purpose of ordering the court to respond to the mandamus petition was to understand the basis for the court's actions. So I'm not sure how this court could discount the district court's explanation for what it wants to do. But even if you looked only at what had gone on in front of the district court, I do think we'd be here saying the same thing, because we'd be implicating the separation of powers in the same way. The district court has set up a process to probe into the government's motives for exercising its prosecutorial discretion. We think it's clear both under Fokker and the constitutional backdrop on which Fokker relied that that's precisely what a district court may not do in adjudicating a Rule 48A motion.
And in Fokker itself, the district judge held a bunch of proceedings before the denial of the deferred prosecution agreement. And would you say that in Fokker itself, those subsequent proceedings should have never happened, and if a mandamus petition had been filed, then mandamus should have been entered because the district judge had telegraphed the kinds of questions he was concerned with?
So I want to separate in Fokker the proceedings that went on before the court granted mandamus and the proceedings that went on after. Maybe I misunderstand Fokker. I did not think that there were very substantial remand proceedings that went on in Fokker after the grant of mandamus.
I mean before the grant of mandamus. I'm saying that before the petition for mandamus was even filed, right, which was before the deferred prosecution agreement was rejected, the district judge scheduled a number of proceedings to ask about the proposed deferred prosecution agreement. Is it your view that in Fokker, if a mandamus petition had been filed when those proceedings were announced, before the district judge entered a ruling on whether he was going to accept the deferred prosecution agreement, the mandamus should have been granted because the district judge had telegraphed where he was going?
Yes, I think it'd be a harder case. It'd be more like Richards because you wouldn't have binding circuit precedent. But all of the reasoning of Fokker, Chief Judge Srinivasan, suggests that it would have been impermissible, that the decision to dismiss pending criminal charges is within the ken of prosecutorial discretion, and the district court can't probe that, whether or not it's made a final decision. This case is easier because now that we have Fokker on the books, if a district court tomorrow said, well, look, maybe I am required to approve the DPA under Fokker, but I still want to have a hearing to cast light on what I think may have been improper conduct by a United States attorney, I would be very surprised if that were not mandamusable in this circuit now in light of Fokker. So I'll grant that.
Last question along these lines. Thank you. Last question along these lines, which is, if the government had filed the exact same 48A motion that it filed, and the district judge had said, thanks for the submission, I want to make sure I understand the government's reasons further, I'll schedule a hearing in X number of weeks, would there be grounds for mandamus on the theory that there's nothing for the district judge to do other than grant the dismissal?
Well, I'm not certain about that, Your Honor. If the district court said, I just want to understand the reasons in your motion, there's ambiguity. I don't understand why it is you want to dismiss. I'm not saying that mandamus would lie for that, but that isn't what the district court is doing here, obviously. This is meant to probe the executive's reasons, and that's exactly what Fokker takes off the table.
Thank you, Mr. Wall. Judge Henderson?
Yes. Let me put a correction on the record so I don't get any aftermath from it. My clerks have informed me that it was Henry David Thoreau who made the remark about circumstantial evidence. Mr. Wall, we asked you to be prepared to address the effect, if any, of 455A and 455B5i. Are you waiting to do that in response to questions? Have you waived it? What's your position?
No, I'm happy to address it now, Judge Henderson. In the government's view, as you know, that Judge Sullivan is not a party under the rules entitled to file the petition. We would say the same thing under 455. I don't see a reason to differentiate the rules from the statute, so I don't think there's a B5I problem. Though for those who think that Judge Sullivan is entitled to file under the rules, I don't understand why it isn't also a statutory problem, because of course 455D says that if you're a party at any stage of the proceedings, and that I think would include the mandamus proceeding. But we aren't urging that, though I'm not sure what Judge Sullivan's counsel will say about that. I do think it's a harder question on 455A. As you know, we did not agree with General Flynn before the panel that disqualification was warranted, even though what had happened in the district court to that point was fairly irregular. I do think we're in a bit of a different posture now because the district court has filed a petition that is not permitted under the rules, which suggests, as Ms. Powell said, a level of investment in the proceedings that is problematic and has gone further than the district court did in the panel briefing to decide the legal standard, and has now definitively said that, and this is pages 14 to 16 of the petition, that Fokker has nothing to say about the separation of powers considerations on these facts, that's page 14, and that Amidon remains good law, that's page 16, and that the district court can undertake its own independent examination of the public interest, that's footnote 3. And so I think now the district court has prejudged part of what I understood the proceedings below to be designed to accomplish. So I do think that we have reluctantly come to the view that there is now at least a question about appearance of impartiality.
All right, thank you.
Thank you. Judge Rogers?
Well, I suppose, Mr. Walden, is your position that the filing by the district court in urging that mandamus was in effect impermissible at this stage, that is the bias that would require reassignment?
No, Judge Rogers, I'm not saying that it actually suggests that the district court is biased. I want to be clear about that. We're not saying we think there's an actual partiality problem, but I do think that...
Hearing.
Oh, but no, we do think that there is an appearance problem from having filed a petition that, as we read the rules, is not permitted, and the substance of that petition, as I said, which goes, I think, an awfully long way if it doesn't cross the finish line towards saying what Rule 48, what the legal standard is. I think that brief essentially says that the district court does not think Fokker sheds light on this. It says nothing about the separation of powers considerations on these facts, and that Amidon is good law and it's going to conduct a public interest examination. And so I think the district court has decided what the legal standard would be, and if the court is going to deny mandamus, I would hope that it would provide some guidance to the district court on what we see as its limited role under the Constitution and Fokker.
Now, I understand the argument about the amendments to Rule 21, but certainly the Supreme Court in Clark indicated the situation that the district court may find itself in. I didn't see any suggestion that would create an appearance of partiality problem.
No, Judge Rogers. I don't think that somebody can create a recusal problem for a judge by filing a mandamus petition. And Rule 21, as you say, solves that problem by allowing the Court of Appeals to invite the district court to respond almost by way of an amicus. It specifically doesn't list the district court as a party. I think the problem here is that because the district court has reached out despite those rules and filed a petition without being invited to do so by the court, it at least raises a question about whether the district court is invested in what should be its official authority to a point where we have an appearance problem. After all, I mean, we've only been able to identify one en banc petition filed by a district judge ever, and that was a situation where the district court's personal reputation was really at issue because of comments that the district judge had made. This is very different. This is just about the scope of the district judge's official authority. It isn't the sort of thing that you would normally think would trigger an en banc petition.
Well, I just want to understand the scope of your position here, because the Supreme Court cases do not appear to have adopted that. And by saying there are questions he wants to ask, as the chief judge framed it, in order to understand the government's motion, that alone is sufficient? In other words, originally all I was going to ask you about was, you know, why should the court consider harm to the government, to the executive branch, when it never filed for mandamus and it never filed any sort of interlocutory appeal? It just, as in Cobell, and it simply waited until it was invited to comment. And then I thought, well, even assuming the court should consider the injuries to the executive, at this point, why aren't the injuries too speculative? Or are you adopting Mrs. Powell's or Mr. Flynn's argument about it's the process itself that signals the extraordinary action by the appellate court reassigning a case to another district court judge is appropriate here?
So 3 quick points, Judge Rogers. Again, I'm just responding to a question that the court has put to me about 455A. We do think that we're in uncharted waters. We think it raises a question, but if the court disagrees with us on that, we think it is important, if the case goes back, that this court provides some guidance to the district court on its role under Rule 48A, and that it take off the table some of this factual inquiry that the district court seems to want to engage in. My second point is, I just want to be clear on my answer earlier to the Chief Judge. There's a difference between trying to understand the motion and the kinds of questions that the district court raised in its panel briefs. Why we didn't charge with respect to the Turkey statements, why we have handled related prosecutions the way that we have, why certain attorneys signed the brief and others. That's a probing behind the motion. It's not an attempt to understand the motion. And so my third point, Judge Rogers, is there's nothing speculative about the injury to the separation of powers from that. No matter how we ultimately answer those questions in the district court, and no matter how it ultimately disposes of the motion, probing the executive branch in that way is what Waite, and Fokker quoting Waite, says is constitutionally impermissible. Those aren't speculative injuries. Those are certain injuries from the process itself.
Well, I have a dozen questions, but Chief Judge, I'll let my colleagues speak.
Thank you. Judge Tatel?
Yes, good morning. I have two questions. The first is I'd like to ask you the same question that Judge Srinivasan asked Ms. Powell, which is, are you aware of any case at all in which a court of appeals has issued a writ of mandamus to prevent a district court from conducting a hearing of any kind?
I believe that there may have been some of the writ of prohibition cases like that, Judge Tatel. I'd have to go back and look, and we'd have to supplementally brief it. I think the closest case I could give you is Cheney, where the district court ordered a discovery plan. It was just a process for setting up discovery. No documents had changed hands. And obviously this court in a divided panel said there were adequate alternatives to mandamus because the executive could assert executive privilege. And the Supreme Court disagreed and said the harm was to requiring the executive to engage in that process in the first instance. And I think the same is true here. Now, granted, that's discovery rather than a hearing on a motion, but I think the reasoning is parallel, that where it's the hearing itself that implicates the separation of powers, just like there it was the assertion of privilege. I don't think we have to wait for the process to play itself out. The process is itself part of the constitutional harm.
Right, but from a mandamus point of view, where the relief has to be clear and indisputable, there is no case where at least you have, I mean, I don't know what those prohibition cases are you're mentioning, but setting those aside, there isn't one where mandamus was granted before the district court actually held the hearing that you know of, right?
No, Judge Tatel, but I would say what I said earlier about Fox, which is if a district court tomorrow said it wanted to have a hearing like that on a DPA, I would think that would be mandamusable in this circuit under Fokker.
Yeah, okay. My second question has to do with the, which is related. In your brief, you argue that it, and I'm quoting here, is a usurpation of judicial power to second guess the government's justification. And then you also argue, quote, the executive is entitled to confidentiality in its decision-making process. But though courts regularly scrutinize the executive's stated justifications, like take, for example, Batson hearing, where the court will review the government's proffered justification, or in Department of Commerce versus New York, the census case, where the question was whether they could have the district court could have a hearing to consider external evidence of pretext. Isn't that this case? The court said in the Department of Commerce, a court is ordinarily limited to evaluating the agency's contemporaneous explanation in light of the existing records. It says, we have recognized a narrow exception to that general rule on a strong showing of bad faith. And isn't that what this case is about? Isn't the district judge here simply looking into whether there's been such a strong showing?
So 2 points, Judge Tatel. The first is, that's not just our view, that's quoting Fokker, which says courts may not, quote, second guess the executive's exercise of discretion over the dismissal of criminal charges, end quote. And the second thing is, no, of course you are right that there are plenty of circumstances, as this court well knows, where courts can scrutinize whether the executive has complied with some statutory or regulatory duty. What makes this different, as Fokker explains, is that the Constitution vests this kind of discretion, the discretion over bringing and maintaining and dismissing criminal charges, in the executive. And so as a separation of powers matter, these kinds of decisions are taken off the table for judicial review, that Fokker says not adapted to judicial review under our constitutional structure. But of course that's not true of any number of other legal questions that aren't the exercise of such a core executive duty.
I have no further questions. Thank you.
Thank you. Judge Garland?
Yes, good morning, Mr. Wolf. I want to just follow up on a question that Judge Tatel asked General Flynn's attorney earlier on. So in your brief, you argue that there's an Article III standing problem, a party standing problem, lack of Solicitor General authorization for this en banc. If it were true, and I ask you to assume that I'm correct about this, that the court granted sua sponte, do you think that the court does not have the authority on its own to rehear a panel's decision?
No, Judge Garland, those problems wouldn't be posed. The question would be then only whether it was an appropriate use of the court's sua sponte authority under cases like Saning Smith to go en banc in a circumstance like this after the filing of a petition that was defective, including constitutionally defective. But we have not argued, we did not argue in our brief, as you saw, that the court would lack the power to do that.
That case is not about en banc, is it? You're talking about the Supreme Court's recent decision?
Yes, it's not about en banc, but it is in part about a court's use of its authority sua sponte to redirect a case in particular ways.
If an en banc panel, if the court as a whole is wondering whether the three-judge panel correctly decided that there's any circumstance in which it can't on its own decide to rehear that matter? Or are we stuck in every mandamus case with whatever three-judge panel happens to decide a case?
No, Judge Garland, sorry if I wasn't clear. You have the power to go en banc. The defects with the petition don't affect that power. The only question would be whether that's an appropriate use of the court's authority, and obviously that would be left to the court. We haven't the court to go respond.
I'm sorry to interrupt, but the chief has been very parsimonious about the amount of time he's given us. Already, you, meaning the government, has already given its reasons for dismissing this case, correct? That is, as the panel says, the government explains that in light of newly discovered evidence of misconduct, the prosecution can no longer prove beyond a reasonable doubt that any false statements were material, right? But that's the government's reason, correct?
That was one of the three reasons, Judge Garland.
I'll take all three of the reasons. So you've stated three reasons, and I assume you believe that those are true, correct?
Yes.
What more is there for you to say? Well, let me put it another way. Let me begin. Was it that optional? Did you not even have to say that much in your motion to dismiss?
I don't think that we did, and we often don't, but under the circumstances here, we went further than we thought we were obligated to. And by the way, Judge Garland, just to drive that point home, the Attorney General, of course, sees this in a context of non-public information from other investigations like...
I'm not in any way questioning anything underlying. I'm just asking, this was the reason given, and you gave this reason.
Yes, I just wanted to make clear that it may be possible that the Attorney General had before him information that he was not able to share with the court, and so what we put in front of the court were the reasons that we could, but it may not be the whole picture available to the executive branch.
So if the judge asks you what your reason is, and you state this as the reason during the hearing, are you saying that's not the end of it? There would be no problem with you saying that, would there?
No, not at all. It's just we gave three reasons. One of them was that the interests of justice were no longer served in the Attorney General's judgment by the prosecution. Yeah. The Attorney General made that decision or that judgment on the basis of lots of information. Some of it is public and fleshed out in the motion. Some of it is not.
All right. So if you stood by this reason when Judge Sullivan conducts the oral hearing, there would be no problem in you doing that, would there, from your point of view? No separation of powers problem at this point, given what you've already stated to say that, right?
If all we had to do was show up and stand on our motion, no, we've already said that to the district court.
Yeah, and if the district court goes further, at that point you could seek mandamus again. But at this point, the district court has not actually gone further. I mean, there's a brief en banc about what might happen, but the district court has not ordered you to do anything other than show up and brief the matter, right?
With all respect, Judge Garland, I think I don't agree with that. After Judge Gleason wrote his op-ed calling for a factual inquiry, he was immediately appointed as an amicus as part of a process that the district court has now explained to this court was meant to probe our motives. And so to say that this is just an anodyne proceeding on the meaning of Rule 48 and all we will have to do is stand on our motion.
I understand that, but you can refuse to answer any further. And if you're pressed further at that point, you can, again, move for mandamus. But there's the possibility that after all this briefing, the district judge will see the light in your view, and that will be the end of the matter. You know, unless there's extraneous outside information that someone other than the government presents, so that there's no probing of the government's subjective motives.
Judge Garland, again, I go back to Cheney and Fokker. With all respect, I just think that undervalues the harms to a co-equal branch from compelling us to respond to improper questions and accusations by the court-appointed amicus about the reasons in our prosecutorial discretion.
In Cheney, there actually was a order of discovery, and there isn't no order yet here. Isn't that right? In fact, it was the most wide-ranging discovery that the Supreme Court had ever seen, it said. Something along those lines. There hasn't been a discovery order yet. Is that correct?
No, there hasn't been a discovery order per se, but there has been an order setting up a process to make us defend the exercise of a core executive duty. And I think to be fair, I think it doesn't take seriously the harms to a co-equal branch from a situation like that, where we are called in to have, questions and accusations thrown our way that we've got to respond to. That's exactly what Fokker says.
Really, every day when I was an assistant U.S. attorney, accusations were thrown my way by the defense counsel. This is part of the job of being a prosecutor. I don't understand how merely being the subject of accusations from the other side, or even from the judge who often questioned what the government was doing, if each of those was a separation of powers case, we would have a large number of mandamus cases in the circuit.
Judge Garland, in the vast majority of those circumstances, there's no separation of powers question at play. In the DPA context, I think it would be fairly remarkable if a district court said tomorrow that even if it had to approve a DPA, it was going to have a hearing so it could air out a bunch of allegations about whether the prosecutors had cut a sweetheart deal with the corporate defendants as part of a DPA. That seems to me exactly the harm that Fokker is discussing in Part 2A. And again, I just think it doesn't take the harm to a co-equal branch seriously to say, well, that's not really harm until the motion is granted or denied, because those are not the only harms that the separation of powers is meant to guard against. It's meant to guard against oversight and scrutiny of this core executive discretion.
All right, I have the argument and I've overstayed my welcome. Thank you.
Thank you. Judge Griffith?
Yeah, good morning, Mr. Wall, and thank you. I'm struggling with the meaning of the phrase in Rule 40AA, leave of court, and what that means. Ms. Powell, for General Flynn, has a very narrow view of what it means. She said, I think it's almost ministerial, and maybe I'm misquoting Ms. Powell. I don't mean to do that. What is the government's view of what that phrase leave of court means? And let me put it to you this way. Is it appropriate in the government's view for a district court judge to have a hearing before ruling on Rule 48A?
I think it depends on as I was trying to say earlier to Judge Srinivasan, what the hearing is designed to do.
Okay, so but there's not a categorical prohibition on having a hearing, right?
No, I'm not saying that once one of these things is filed, the district court just has to stamp it and send it out the door. The district court the question that becomes what's going to happen at the hearing. Is that right? I think, but if I could just go back to your first question, I think Rule 48A has a role to play with respect to opposed motions. We know that. With unopposed motions, we know the focus is the harassment to the defendant. I would say that also the district court can make sure that it's got the authoritative position of the executive branch, which it might not if you have a prosecutor that's been bribed or gone rogue. It can make sure the defendant's been counseled and is not agreeing to a harassing motion to dismiss against the defendant's interests. But I think that beyond that, which I'll grant is a fairly narrow conception of the rule, that's what Fokker says, I don't think that there's a substantive role for the court to play. That's what the Seventh Circuit said in the United States. It's even what the Third Circuit said in Richards. It said no substantive authority. You can ask for the reasons.
What if the court has? What if the court is concerned about favoritism being displayed to a politically powerful defendant? Is that a proper reason to have a hearing?
No. That is a concern that is not the domain of Rule 48. That has political.
What's your authority for that?
So that's, I would say, in the United States, I'd say Richards, I'd say Fokker, that it doesn't matter what the district court may believe that the government has a bad motive, and that bad motive could be all sorts of things, favoritism or something else. But everybody agrees that the United States can't be made to bring a prosecution, even if it should, even if its motive for not commencing one is irregular or impermissible. And the same is exactly true of dismissing or maintaining a prosecution. There are checks on that, plenty of checks on them in our political.
Okay, what would be an appropriate hearing for Judge Sullivan to call on these facts in this case? What are the outer limits of what he could do that the government would think is appropriate?
Oh, I don't think that there is one on the facts of this case. You have a well-counseled defendant. You have the
no hearing at all. I'm sorry. So you're saying on the facts of this case, no hearing at all would be appropriate?
Well, if he needs to understand the motion, but as a substantive matter, to try to get behind the motion for some motive or another, no.
So what do you mean if he needs to understand the motion? I'm trying to get at what you think would be an appropriate hearing for Judge Sullivan to call in this case. What would that hearing look like?
On these facts, I don't think there is an appropriate hearing that could be had, Judge Griffith. I think in other cases, you can imagine where a district court was just trying to understand the law. But here, Judge Sullivan's briefs make clear that he understands the law. He thinks it's a different standard from what I read Fokker to have. But he wants a hearing to probe our motives. No sort of hearing like that is going to be permissible.
Okay. Thank you very much.
Thank you. Judge Millett?
Yes. Good morning, Mr. Wall. So, question. First of all, I thought Ms. Powell had said, and I'd just like you to clarify, does the filing of a 48A motion by the government have to get approved by the Solicitor General and or Attorney General?
I don't know about I think it is rare that they go all the way up to the Attorney General. The Solicitor General is typically not involved. The Attorney General was involved here.
Sure. No, I got that. Okay, so it's not something that routinely happens. I want to make sure, I'm trying to figure out like Judge Griffith here, what that leave of court is meant to cover and to help understand what it doesn't allow. It helps to understand what it does allow, for me at least. And so I think you may have said this would be okay, but I just want to confirm. I had asked Ms. Powell, referring Judge Wilkins hypothetical about information coming in from a buckload of nuns who have seen money a suitcase of money pass from a defendant to the AUSA. And so do you agree that it would be appropriate for the district court under Rule 48A to have a hearing and ask the government what was the real reason for your decision? You said in your motion, I think it's hypothetical, it was Brady violations. Evidence has come to my attention, maybe it's wrong, of a bribery, but here's the video. Can the district court push and ask that question? What's the real motive here? Was it a bribe or was it Brady?
I don't think, in a sort of evidentiary hearing way, no. The court can call in. That's
not what I said. What I said is have the attorneys come in for a hearing. And it's evidentiary only in the sense that here's the video. I've shared it with you, counsel, both counsel. You know what video I'm talking about. Maybe he even plays it again in court and says, what is your real reason?
Judge Millett, I don't think that's appropriate. Here's how I think that should be handled under Rule 48A. I think the judge can call in the U.S. attorney and say, do you really want to...
Yeah. I don't, but so the district court cannot ask whether it was lied to by the government in a filing made with it.
Well, not under Rule 48A. It can certainly ask for purposes of sanctioning an attorney before it under other authorities.
Can it do that after it dismisses the case, or does it need to do it while the case is still pending?
No, I think it could do it before or after as a matter of sanctioning an attorney under...
But before, I don't know if, just tell me, I have no idea. Can you issue sanctions or hold a government attorney in contempt after the case is dismissed? Or do you need to do that before it's dismissed?
I don't know the answer, Judge Millett. I would think that the answer is the court can continue to supervise officers of the court even after granting the Rule 48A motion.
Okay, so it's clearly not settled whether the district court then...
Oh, it may be. I have a question.
Right. Okay, well, I couldn't figure out either, but that you'll have more experience than me. That's probably...
But again, I just want to say the basis for that is not Rule 48A. The basis for that would be...
The question is, you have a motion to dismiss, and at least Ms. Powell's argument is grant it and go home. And the district court looks at that motion and says, I fear I've lied to you in that motion. Your position is the district court nonetheless has to grant that motion in which it feels it was lied to, and maybe it's a violation of court rules, that very document it nevertheless has to grant it and can't inquire about whether it was lied to. That's the government's position before granting the motion.
Exercise prosecutorial discretion is not substantively reviewable in that way.
The Rule 48A, when it says leave of court, and as you know, the Supreme Court has left open the question of whether there's any other public interest besides harassment of the defendant into which a court can look to. And your position is protecting the integrity of the court and the very process in front of it is not, I'm not talking about any general public interest, I'm talking about this very narrow interest of protecting the integrity of the court and the court process. That's not allowed.
I'm saying that's the domain of sanctions and contempt. It's not relevant in the 48A.
Okay. There is it your position that there is no such interest inquiry?
Of the kind you're outlining, yes. No such inquiry is appropriate under Rule 48A.
So it's just limited to defendant harassment?
It is defendant harassment and ensuring that the parties have reached counseled authoritative positions. But when they no longer want to proceed, and that's a counseled, considered choice by both parties, yes, the court cannot keep the criminal prosecution alive. Article 2 and Article 3 do not permit that.
And then did the United States raise an objection to the appointment of Mr. Gleason, the court-appointed amicus, in the district court?
No. May I explain why?
Did you make? I'm going to get you a couple questions because maybe you'll explain them together because I'm getting nudged by the Chief Judge here. And did you object to the briefing order, the schedule that the district court laid out, which you said subject to motion for reconsideration? You didn't do that either. No,
not other than the arguments we made in our motion to dismiss.
Sure, right, got that. Okay, and then, but go ahead and answer that. And sorry, Chief Judge Srinivasan, but I have one more quick procedural question, but I don't want to cut you off on your full answer to those two, which are, I think, maybe.
Only very briefly that the court didn't provide notice that it was going to appoint an amicus, and when it did it immediately after the publication of Judge Gleason's op-ed, it seemed to us a considered decision, and it did not seem worth moving for reconsideration, and we were not aware of any requirement to ask for reconsideration of a sua sponte decision, especially a considered one. So, no, we did not go in and tell the district court that it should not have done that.
Okay, and then one last thing. There's been some talk about recusal and the judge's asserted bias or self-interest in the case. In the government's view, just generically, is mandamus appropriate to raise recusal issues if the district court judge if the parties haven't first asked the district court judge to recuse?
I think that would be an odd requirement where part of what gives rise to the potential appearance of impartiality is the conduct in the mandamus proceeding itself.
I think the mandamus petition itself, even before there was any filing by Judge Flynn, already asked for disqualification of the judge. So I'm asking, are you aware of any case that has granted that on mandamus has granted recusal without someone first asking the district court to recuse?
No, I'm not aware that a court has ever been faced with a situation like this one. I mean, this is an unprecedented en banc petition.
All right, thank you.
Thank you. Judge Pillard?
Good morning, Solicitor General Wall.
Morning.
I think we all agree we owe huge deference to the United States government, and there's not a judge in this city that questions that. And I think it's clear that courts owe virtually complete deference to the government under Rule 48A. And I appreciate that it was General Flynn and not the United States that initiated the mandamus petition, and that General Flynn alone sought recusal of the district judge, at least at the panel stage. But, the integrity and independence of the court is also at play here. The separation of powers is protecting Article 3 courts also. And in this case, the district judge was also skeptical in the plea colloquy, accepting the plea in the first place. And in fact, Flynn would have been sentenced long ago, but for Judge Sullivan's skepticism and saying, if you don't want to do this right now, take more time, talk to your counsel, I have a room for you. But then the district judge, at your urging, at the government's urging, accepted the plea as factually supported by the government's evidence. The government urged, he didn't dream up this order. He didn't dream up the plea of guilty. And the government demonstrably said, we can meet our burden of proof beyond reasonable doubt. He looked at that. He scrutinized that. And now you're insisting that the district court contradict an order that he previously granted. He previously got on board, and you're saying, actually, never mind. Rule 48 requires leave of court. He has to participate. The rule calls on him to play a role. And I'm just, what self-respecting Article 3 district judge would simply jump and enter an order without doing what he could do to understand both sides? To understand both sides. He wasn't appointing Gleason to be the judge. He was appointing Gleason to make the strongest arguments. And he understood and trusted that the government would make its strongest arguments, and he would therefore, in the adversary system, have the strongest understanding of what was before him. And I appreciate, I've listened carefully, I appreciate that your argument today has focused almost entirely on the prospect of a factual inquiry that I think you said the district judge seems to want to engage in. But all that was scheduled was briefing and argument on the law, right? It was briefing and argument. He never said factual development was necessary. Yes, Gleason asked for it, but there's no order of discovery here. So if it's just lawyers' arguments about the existing record, just lawyers' arguments about the existing record, what is the intrusion on General Flynn's clear and indisputable right?
2 points, Judge Pillard, and they're really critical. The first is, you are certainly right that the government no longer wants to prosecute, and that's true for any case in which you've got Rule 48, and for a small subset of them, you actually have a plea. We're not asking the district court to contradict anything that it's done earlier. As Fokker says, the Rule 48 motion, like approving a DPA, says it involves no formal judicial action, and the court never exercises its coercive power. So accepting a plea is different from simply allowing the executive to let a case go as a constitutional matter. And to take the second part of your question, you're right that the district court below never entered an order per se and said there'll be fact development. He just appointed an amicus that had called for it and has now filed briefs asking for it. But he has said that to this court, both in his briefs to the panel and even more explicitly at various points in his rehearing petition. Now, at argument below, I think the district court's counsel backed away from that and said he just wants to have a hearing and ask some questions. And the dissent accordingly believed that discovery and evidence and this kind of factual probing wasn't at issue. If the court really thinks that's not at issue, then I think that should be among the limits that it should place on the district court when the case goes back. If all we're doing is arguing about Rule 48, it's hard for me to see then what we're going to do below, because the district court has explained what its legal view is. There's no basis for looking behind what we've done on the face of the motion itself. So then I'd say it's even clearer that we ought to get mandamus, because there's no reason to have any unnecessary proceeding. If it's not meant to probe behind what we've said, and if what we've said satisfies, as you agree, is a very deferential standard, it's hard for me to see what the point of these further proceedings is at all. Then I think the panel was clearly correct to enter mandamus.
Doesn't it cut exactly the other way? You haven't even asked the district court to rule yet. The district court hasn't ruled. I think that's just a basic differential between this case and every other case except for Richardson. I just, one follow-up. You said you're not asking the district court to contradict himself, but you are asking him to accept. I mean, if you weren't asking him to do anything, you wouldn't be here to mandamus him, right? You need the judge to sign off on the Rule 48A. And, right? I mean, right now there's a plea in place. He could call a sentencing hearing tomorrow, presumably.
That's right, Judge Barr. So 2 points. One, in the motion to dismiss, quoting Fokker and a number of the Supreme Court's cases, we laid out the fact that we thought we were entitled to have the motion dismissed granted. Rather than accepting that argument, the district court has convened this entire proceeding, invited the public to participate, and raised the specter of contempt. But in moving forward with it, we're not asking the district court to contradict itself. It found before that there was a factual basis for the plea. We're not asking the district court to say anything different. We are only asking the district court to say the Attorney General has now made a policy judgment that it is no longer in the interests of the United States to prosecute, whether or not the government could move forward and there's an adequate factual basis. And I am bound to that decision because that decision is vested in him under the Constitution. There's no inconsistency between those two things, and that's why the court says in Fokker that signing off on a DPA or allowing the court to dismiss a prosecution is not like accepting a plea under Rule 11. It doesn't invoke the court's coercive power. It doesn't involve formal judicial action, adopting or imposing anything. It just agrees to let a case go indefinitely.
Exactly. It's just really striking and remarkable. What is the government worried about if none of the inquiry that you're highlighting has even been scheduled? He wanted an argument. Anyway, I think that I understand. The only last question I have for you is, do you agree with Ms. Powell that it's not the reading of Rule 48A that imposes the severe limitation on the court being able to deliberate, but the separation of powers overlay? Because the history of the rule seems to be that there actually was quite a robust contemplation that judges would scrutinize whether there was, for example, political favoritism. And is it also your view that that doesn't matter if that's the right way to read the rule because separation of powers would render that unconstitutional?
I think that overstates the history. There are some members of the drafting committee that mentioned favoritism as a concern, but they didn't put any mechanism in the rule for allowing the court to superintend prosecutions in that way. So I'm not sure the history is as clear on this as...
But just leave of court, yeah.
It is just as Fokker said, it's reading that language in light of constitutional principles and avoidance. And just to go to your other question very quickly, when you say, look, what are the real harms? I think that's Cheney all over again. It's what are the harms? You can assert executive privilege. What are the harms? If you want to show up and you want to have these questions, you don't have to answer them. You can stand on your motion, and if the district court is frustrated, he can hold you in contempt, he can grant, he can deny the motion. What's the big deal? And I think just as in Cheney, that understates the harm to the separation of powers. I would say the same is true here. It's hard for me to read Fokker and think that's not among the harms that Fokker is talking about to the executive branch.
Okay, Mr. Wall, just the very last. Shouldn't the district court be able to hear and consider, in light of the strongest arguments, and I'm not talking about facts, whatever's in the record now, period, assume that that is all that there is, but shouldn't the district court be able to hear and consider, in light of the strongest arguments on both sides, why the government believes the evidence is now doesn't support going forward? Your view that he should not be able, that Rule 48A does not authorize him to have a lawyer's talking kind of hearing to guide him in exercising the leave of court authority.
We haven't said that a district court doesn't have the power to appoint amici in criminal cases generally. The problem with the appointment here is that, like everything else the court is doing, it is designed to entrench on executive power. So if a court tomorrow said, look, I'm not sure whether I'm going to approve this DPA, I think maybe it's too lenient on the corporate defendants. I want the best arguments from both sides about whether I should approve this or whether it's too lenient. And so I'm going to appoint an amicus. I think Fokker squarely forecloses that. It says there's no substantial role for the courts. And whatever the district court...
He didn't say that, though. If he just said, I want to understand. I'm sorry, I'm interrupting. It's my feeling of urgency because I know the chief wants me to move on. But if he just wants to understand what the government's position is, and he thinks the adversary system is the way to get there, and he's going to appoint the devil's advocate on one side and have the government argue strongly on the other, that you don't have any objection to that.
Judge Pillard, just to be clear, that's not what this is. The district
I understand that we have a difference of opinion on that, but we've been asked to mandamus, and so we have to draw a line.
That's right, but the district court told you in its brief, if you look at the rehearing petition, pages 14 to 16 and footnote 3, it says it wants to see whether the public interest is served, and what it says is, quote, legitimate prosecutorial interests. This is not a lack of understanding on the part of the district court. The briefs of the district court are very good. The district court fully understands the United States' position. What it wants to inquire into is whether that position is, in its view, quote, legitimate. And that is exactly what Articles 2 and 3 do not allow.
Thank you.
Thank you. Judge Wilkins?
Yes, good morning, General Wall.
Morning.
So, in your view, Fokker forecloses any factual development at a Rule 48A hearing? Yes or no?
Beyond ensuring that you have the authoritative positions of the parties, yes. You can make sure the defendant is counseled. You can make sure that the prosecutor hasn't gone rogue or been bribed. But outside of that, yes.
So if in my hypothetical, there is a videotape of the U.S. attorney taking a suitcase full of cash, and the judge wants to have a hearing on that because that same U.S. attorney signed the motion, you would say that that hearing is appropriate or not appropriate under Rule 48A?
I would say the hearing to make sure that the executive branch actually wants to dismiss is not a problem. But if the U.S. attorney shows up and says, I want to dismiss, we'll deal separately with whether the AUSA committed bribery. No, the court can...
No, my hypothetical is that excuse me, sir, my hypothetical is that the U.S. attorney is the one in the videotape taking a bribe, and the judge makes that factual finding, that the person standing in front of him, the U.S. attorney, is the person in the videotape.
Again, that's the toughest case at the margin, I'll give you, but my answer is still the same. The court can ask the AG or the Deputy Attorney General whether they really want to dismiss. If the answer from the executive branch is yes, then whether some individual in the executive branch has committed a crime is not the domain of Rule 48A. The executive branch could prosecute, and the court could sanction or have contempt under separate authorities, but it would not be a basis for denying the Rule 48A motion. It would be a separate criminal proceeding involving the corrupt United States attorney.
And that is based on Fokker.
And the constitutional backdrop on which Fokker relied. If the Attorney General said in your hypothetical, yes, I want to dismiss, I have lots of good reasons, I will separately look into whether the United States attorney took a bribe, I think the court would be required to grant the motion and dismiss the prosecution. It couldn't keep it alive.
So suppose there's a hypothetical situation 10 years from now, different administration, where the Attorney General is in the videotape by the nuns taking the bribes. No authority under 48A to dismiss that case?
No, my answer is still the same, and the political and public remedies for that are I think, sort of so obvious that it wouldn't need to be the domain of Rule 48A, and I don't think anybody has contemplated that Rule 48A is meant to aim at that sort of public corruption.
Well, so the case would still get dismissed as to that defendant who bribed the Attorney General. The Attorney General might be able to be prosecuted or impeached, but the defendant would still get off scot-free as a result of committing a bribe.
Maybe if
that's the way 48A works.
Maybe if I could come at it a different way, Judge Wilkins. In the vast majority of cases where what we're talking about is not commencing charges, I take it everyone, even the district court, agrees that there's no rule for courts to play under Rule 48A, even if they think that the executive has failed to prosecute for some improper reason, like bribery, like favoritism, like corruption. Everyone agrees that the executive can't be made to prosecute the case, no matter how impermissible its motive for declining to do so. And all we're saying is that as a rule-based matter, the same rule applies to Rule 48A if we have brought the charge. Fokker says dismissing is the same as bringing as a constitutional matter. It's bad conduct, to be sure. It should be punished, to be sure. There are other remedies for it, but they don't concern Rule 48A.
Well, a 48A motion could be made after sentencing. So you're saying if the Attorney General is bribed by the defendant after the sentence because the defendant didn't like the sentence that he got, the court would still have to vacate the conviction based on 48A, even with a videotape evidence of a bribe to the Attorney General.
As Fokker says, there is no substantial role for courts to perform that sort of judicial scrutiny and oversight. The executive branch's conduct of prosecutions is governed, but it is governed by the legislative branch and the public through means like legislative oversight, impeachment, and the rest. It is not governed by courts under Rule 48A. That's right.
Okay, thank you. That's all I have.
Thank you. Judge Rao?
Thank you. Mr. Wall, I guess my first question to you is, in light of the dissent accompanying the panel opinion, which rested in significant measure on the failure of the government to file a separate mandamus petition, and then the subsequent grant of rehearing en banc, why has the government not filed a separate mandamus petition at this point?
So I think, Judge Rao, I understand the arguments about sort of the timing on the harms. I don't really understand the argument that the court can't look at the harms or that we needed to file a separate petition. We're a party. We filed a brief for the United States. We articulated at length our harms, and in the conclusion, we urged mandamus. I take the line between cases like Cobell and ExxonMobil to be whether we have filed and sought the relevant relief, not how we captioned the brief. Nothing here would have been different if we had filed exactly the same brief, but we had said it's a brief for the United States and a mandamus petition. And we haven't been able to find any case from any court where an appellee supported an appellant or a respondent supported a petitioner, and the court didn't look at the arguments that that party was making in support of the relief. So
I may agree with you as to that argument, but at this point, it seems that at least some members of the court do not. So.
I understand that there may be disagreement over that, but I just think that it would, to have come in now and to have filed a late-breaking mandatory mandamus petition that would have been word for word what we had already put in front of the court is exactly what I understand Cobell and ExxonMobil to say isn't necessary. And I think it would have been distracting. It arguably would have been dilatory in the same eyes of the members who think that we should have filed earlier. And again, even if you thought that there was some problem with our raising those harms as a party, as a respondent supporting petitioner, which we do routinely in the courts of appeals, indeed there's a Supreme Court rule expressly designed to allow this, I still think General Flynn can raise the harms under cases like Bond, because after all, it's not an abstract separation of powers we're talking about. It's meant to protect individual liberty. He has his own Article III injury, hence he can raise the separation of powers violation. And even more generally, with respect to equitable relief, courts look all the time at the interests of third parties in deciding whether to grant or deny equitable relief. So it's hard for me to understand how the court, if it can do that, can't, in granting mandamus, look at the harms to a party that actually filed and requested mandamus. I think it would come down then to saying we didn't caption our brief a particular way, and I don't understand anything in the rules or common sense to recommend that approach.
Okay. So no one here seems to be suggesting that the district court can deny the Rule 48 motion on the facts here. And if we accept your argument, that probing the reasons behind the executive's decision about whether to prosecute infringes on Article 2, and that harm is pretty clearly established by Fokker and other cases. It seems that in our cases, you've talked about Cheney, when the court has found a harm to the executive branch or found a separation of powers violation, that an appeal is not considered an adequate means of protecting the executive power. And I think that is also what the 1998 Field case stands for, involving the independent counsel and Cobell. And I'm just wondering if you are aware of any cases in which we've found a separation of powers violation or a harm to the executive power and then not granted mandamus because we've waited for the executive branch to appeal?
I am not aware of any case, Judge Rao, where the resolution of a motion was compelled by clear law and the conduct of hearing the motion would violate Articles 2 and 3 or any other constitutional principle, but mandamus was denied. The closest example, of course, is the Seventh Circuit, where the Seventh Circuit granted mandamus. So, no, I'm not aware of anything like that. I understand that there's some skepticism on the court about doing it at this stage. We do think that Cheney and other cases make clear, Fokker among them, that an appeal is not going to be an adequate remedy for the government because of the harms it faces from the process. But if the court disagrees with that, I think at least what it would need to do are to place on it the limits that the panel dissent thought were implicit in the proceeding and that the court have indicated. I think it would need to indicate to the district court that it needs to take a harder look at Rule 48 and Fokker because its role is a limited one. I think it needs to take off the table the sort of fact development the district court is trying to hold open, notwithstanding the panel dissent. And I think the district court would need to make a quick decision so that we could come back to the mandamus panel in a timely way.
Thank you.
Thank you. Mr. Wall, just one quick question. The Seventh Circuit case, that's the United States case?
Yes, sir.
And that one, the Rule 48A motion, was denied by the time mandamus was granted. Is that right?
Yes, that's right.
Okay, thank you. Judge Henderson?
Yes, I just have a quick question, Mr. Wall. When the trial judge appointed amicus, he also asked that amicus to opine on whether Flynn had committed perjury or contempt, and you referred to it as the specter of contempt. But aren't there two ways to look at it? In other words, it protects the Article 3 interests, because if a trial judge thinks he's been hoodwinked or dealt with dishonestly, he can hold whoever's responsible for it in contempt. On the other hand, it could also indicate that Judge Sullivan is thinking, well, I may have to dismiss the charges, but I'm not through with him yet. You have a position on that?
Judge Henderson, I will say, although it's not our goose being cooked on the contempt piece of it, I find it maybe the most troubling part of the case, because as the National Association of Criminal Defense Lawyers explained in their brief in the district court, it is not an uncommon occurrence for a defendant to plead guilty because he thinks that's the best deal he can get, and then to later decide that he wants to withdraw his plea and maintain his innocence. That is a fairly common proceeding in a district court. As far as the folks in the criminal division are aware at the Department of Justice, no district judge has ever raised the specter of contempt for that. It's happened in front of this district court before. I'm not aware he's ever raised the specter of contempt for any other defendant, and the reason is that the Supreme Court's cases are clear that that may be perjury, but it's not contempt. And even the court-appointed amicus hasn't tried to make an argument that it is under cases like Hudgens and Michael. And so I think that raising that it creates a real question about why now and why this defendant. Again, it's not a harm to the separation of powers, so it's not something we focused on in our brief. But I do, Judge Henderson, think it's fairly troubling, and in terms of your dichotomy, more the latter than the former. It seems more a sword over the defendant's head than the sort of thing that this district court is legally entitled to do. I'm not even sure how it's arguable under cases like Hudgens and Michael. No one has tried to make the case. The district court has never even addressed that in its briefs to this court.
Thank you.
Thank you. Judge Rogers?
I'll pass.
Thank you. Judge Tatel?
Mr. Wall, I just have a quick, more or less summary type of question. Could you just tell us what's your very, very best argument your very best argument, given there are so few Rule 48 cases, what is your very best argument that it's clear and indisputable that the district court has no substantial Rule 48A role under the circumstances of a case like this, where one, the government seeks to drop a prosecution after the district court accepted a plea of guilty, and number two, the district court has not acted on your motion to dismiss? What's your best argument that it's clear and indisputable under those two circumstances together?
So I fear this is not going to persuade you, Judge Tatel, but I'm reading from Fokker.
I ask the question because always open to persuasion.
Decisions to dismiss pending criminal charges lie squarely within the ken of prosecutorial discretion. To that end, the Supreme Court has declined to construe Rule 48A's leave of court requirement to confer any substantial role for courts in the determination whether to dismiss charges.
Right.
And the court in Fokker went on, by the way, Judge Tatel, to distinguish Rule 48 from something like Rule 11. So I think it specifically rejects.
Right, but that case involved neither of two circumstances present here.
Well, two things. One, I think I granted earlier, I meant to, that it would have been a harder case, though I think it should have come out the same way if there had been no hearing there. Once it's on the books, I don't understand what difference the hearing can make, because that's part of the process that's foreclosed, as we know, by the constitutional backdrop. And then that just leaves the distinction between the pre-plea and the post-plea situation. But I understand Fokker to reject that. Rule 48 does not, like Rule 11, set up different standards for stages of the proceeding. And of course, the constitutional principles that led Fokker to interpret the rule in the way that it did are the same, because you need the adversity and you have to respect the prosecutorial discretion throughout the case. There's nothing magical about the plea. It doesn't enter a judgment of conviction even, and there's still many things that go on in front of the district court. There would be many things that went on here if this Rule 48 motion were denied before we got to a final judgment. So the text of the rule doesn't distinguish, the cases don't distinguish, the constitutional principles are the same. So once we know that Rule 48 is not meant to do this for the pre-plea situation, I don't see how the court could say that as a rule-based matter, it's meant to do it for the post-plea situation.
I have no further questions. Thank you. Thank you.
Thank you. Judge Garland?
Yes, thank you, again, General Wall. So you were asked about how often we grant a mandamus in separation of powers cases, and you sort of amended the question by saying what really matters here was the process, and in answering Judge Patel's question, you said the real problem here is just the hearing itself. So I'm trying to figure out how we draw a line between this kind of separation of powers claim leading to mandamus and the many other ones that we have in the district court not leading to mandamus unless we're going to have a flood. So there are a lot of separation of powers cases that challenge actions of various administrations under the separation of powers. And in fact, the argument in the Appropriations Clause case that we just heard on Bank, our last on Bank, was that the allegedly unauthorized spending by the executive, if permitted to go forward, would constitute a violation of separation of powers. So here's my hypothetical. Assuming they're standing, and assuming that that claim is indisputable, would it be appropriate for a plaintiff to petition this court to mandamus a district judge to rule in its favor and not wait for the district court to ever rule?
In a case between private parties, Judge Garland, I'm not sure that it would. I would limit it in three ways that I think cabin your concern.
The parties of representatives or the Congress as a whole. In other words, the Congress claims, in my hypothetical, the Congress claims that the executive branch, in disregard of the Appropriations Clause, is spending money. And in fact, imagine that the executive branch just says, we don't care about the Appropriation Clause, we're going to spend it anyway. Why is that kind of separation of powers claim remedial, while the having to go to a hearing claim that you have here is non-remedial. I'm only looking at that adequate alternatives ground.
Right, and so if we've assumed away all the threshold questions like standing and all the rest,
yes.
Just to preserve our objections on those grounds.
I understand. I'm not trying to decide the other case today.
Right. I guess I'd say a few things. One, the constitutional principles have got to be crystal clear, and here they are under Fokker. You've got to have the clear and indisputable right, not just be correct on the merits, as you know.
Oh, all right. I'm giving you the hypothetical. The Constitution says appropriations are made by the Congress, and the executive says, I don't care. I'm going to spend the money anyway. So
right.
It's indisputable that there's a violation. I'm not saying that's the circumstance we're in. I'm just asking you if it's indisputable. Or imagine now the Supreme Court has also held in another case that the executive can't, which hardly seems necessary, the executive can't spend money without appropriations from the Congress. And what? And does that not even have to be heard by the district judge?
No, so I'd say two other things, Judge Garland. First, it's not the district court imposing the injury. It's an interbranch dispute. But the writ of mandamus is about confining a district court within the bounds of its lawful authority. So this is much more squarely within the and there. And, of course, here you have the executive branch in the case raising the harms from what the district court is doing. In your hypothetical, you can pay back money, of course, but here you can't undo the scrutiny from the district court's process that it has set up, which usurps our exercise of prosecutorial discretion. There's no way to undo that harm.
And looking at the alternative remedies, paying back money where it's been spent on various laborers to do things is not a realistic answer to that question. The claim in the hypothetical I'm raising is that the money is being spent, and that is, or is about to be spent, and that will constitute an irreparable injury to the congressional branch, and the money can't be obtained because, in any practical way because it's being spent on goods and services that can't be given back by anyone. So why is your going to a hearing, you meaning the executive branch, more important or more irremedial than Congress's authority to determine spending?
So I assume that's a situation, though, where a party is coming in and asking for an injunction against the spending of the money. But mandamus, as you know, is a writ directed to the district court because the district court is opposing. There, it's an executive injury. So, yes, you'd have to run the equitable factors on likelihood of success and the merits and equitable interest and all the rest. But I don't think it's a problem for the court in terms of if it were to grant mandamus here, why not mandamus in every other case? Because here, what you have is you've got clear circuit law and you've got a district court that's put in place a process where the harms really can't be remedied later.
Let me just adjust the hypothetical one more time. What I'm asking is whether the judge can be mandamused to make a ruling. So imagine the district court says, somebody applies for a preliminary injunction, and the court says, all right, well, I'll hear it. We're going to have a big hearing. I don't care what the Supreme Court said about this. I want to have a big hearing, and I want a bunch of facts. And Congress's argument is every day separation of powers is being violated. So the mandamus would be directed against the district court to make a decision it has not yet made, which is what you're asking the district court to do here, asking us to do here. Order the district court to make a decision it has not yet made.
I don't think so, Judge Garland. I think the difference between a case like that one and a case like this one or Cheney is that the separation of powers doesn't itself require federal courts to stop injuries imposed by the executive. You've got to satisfy whatever the legal requirements for an injunction and all the rest. It does, as Cheney says, prohibit federal courts from injuring the executive in particular ways. That is the traditional function of a writ of mandamus, or at least one of them. So I think that's the difference between your hypothetical and this case. Cheney and this case can be on one side of the line without sweeping in all of the kinds of cases that you're concerned about.
Okay, thanks very much. Appreciate the answer.
Thank you. Judge Griffith?
Yeah, General Wall, I just have one quick question, I think. You're right to point us to the separation of powers concern here, and that's critical. But help me understand, how is it a breach of the separation of powers for the government to be asked questions? Why can't it be the case that at this hearing, if an inappropriate line of inquiry is followed, the government objects, interposes an objection, and doesn't answer, and then that gets appealed, and we follow the normal course? Isn't that how we normally deal with claims that separation of powers are being violated by asking questions that are inappropriate?
So, Judge Griffith, that was exactly the court's reasoning, this court's reasoning in Cheney. Look, all the executive needs to do is assert the privilege, and then we can deal with the harms from if the district court requires you to turn over something that you say is privileged. But what's the harm, this court said, in simply requiring the assertion of the privilege? And the Supreme Court said that was insufficiently respectful of the harms to the executive branch. And I'd say the same thing here, and Fokker supports this. There is a harm that I think this court should not undervalue to making the executive come in and respond to the kinds of accusations that this court-appointed amicus has put in a 70-page brief that by now the court has read. And simply, I think it diminishes the interest of a co-equal branch to say, well, what's the harm in being called to account like that? What's the harm in having to answer all of those? If you don't want to put on evidence, you can decline. If he wants to hold you in contempt, he can. That entire proceeding, which I think threatens to be a spectacle in front of the district court, frankly, is what Articles 2 and 3 are meant to place off limits. Once the executive wants to dismiss and the defendant agrees, there's no controversy left between the parties, and the court's injecting itself in a way that, as I say, creates real harms to the executive.
Thank you.
Thank you, Judge Millett.
Yeah, I'm just following up on that question from Judge Griffith. In other criminal cases, and Cheney wasn't a criminal case, in other criminal cases, when there's been a question to dismiss or not, and courts have, I'm thinking of United States versus Armstrong, crack cocaine, and whether there was racial bias in the prosecution. And when the district court insisted over the government's objection on discovery that the government didn't want to do, it just said, no, we cannot comply. Go ahead and enter judgment against us, and we'll appeal. And when I try to understand your harms here, sometimes in the briefs it sounds like you want mandamus against Mr. Gleason and his arguments. But at this point, we don't know what the district court would ask. We don't know what the district court would insist upon. Even if the district court asks something and you say, we're not going to answer because of privilege or separation of powers, you can just do that. There's nothing that compels you, as in Cheney, to start turning over documents. But you can just say we refuse to comply. As the government does, I won't say commonly, but not uncommonly, it says, fine, rule against us and we'll take our appeal. Why isn't that? There's nothing here that requires you to disclose. You don't have to respond to every argument made by Mr. Gleason. Government doesn't respond to every argument an opposing amicus or party makes. So you say what you said already. We stand on our filing. We will say no more. And if the court thinks that's a basis to rule against us, we'll take our appeal. Would that process not protect you against any separation of powers injury? Armstrong?
I don't think it would, Judge Millett. 2 points. One, as you know, Armstrong is an exception to the normal rules justified by the Equal Protection Clause, and even that exception is a very tightly cabined one. It sets up a very high hurdle, and only where you've got clear evidence of an unconstitutional motive. We don't have anything like that
I'm
here.
just talking about the process for the government to avoid injury. I'm not talking about the constitutional issue there versus here. I'm talking about the process for the government to avoid injuries. If you get a question, you ignore arguments you feel like you don't have to answer. You just say, we refuse to answer. They're not relevant. They're not legally relevant. We will not address them.
Right, so that was going to be my second.
Information. Right, and you just say that to the district court.
But my first point was just that probing the executive in the way that Armstrong allows is a very narrow exception required by the Constitution.
That was the ultimate Supreme Court holding. I'm talking about the process by which the government responded
Right.
Right. That was in the government's position in the lower court in Armstrong. The process was used there, and it could be used here and avoid any harm. No one makes you, right? No, if the worst would happen, I suppose, is throw an attorney in contempt and you get an immediate appeal of that too. But that wasn't even, no one's even mentioned that. So that would completely protect you against disclosing anything that you don't think you should have to disclose.
But I guess what I've been trying to say, Judge Millett, is that I think the process itself is harmful, and if a district court said tomorrow, I want you to justify this DPA, and if you don't want to explain to me why you've entered into it or why you've taken a sweetheart deal, then, you know, you can stand there as the amicus says various things, and I create a record on your silence, and I take that to be the sort of harm that Fokker says is not permissible, because you're extending the criminal process, you're exposing or asking the executive to expose its deliberative process, you're threatening to reveal sensitive information because of course
Wait, no one's threatening to reveal, because you've got complete control over that. And so asking the government to reveal something that the government considers to be privileged, and maybe the district court's wrong as rain, but the district court thinks is an open question, that's mandamusable every time a question like that is asked in a district court across this country? That's mandamusable?
No, Judge Millett, when a district court in this circuit begins to probe in that way with respect to a DPA or a Rule 48 motion, it is mandamusable under Fokker. And the reason, and I may not persuade you, but the reason is that the harm from usurping a constitutionally vested power in another branch is not undone.
Well, just to be clear, asking questions is the usurpation. Just to be clear, your position is no one's forcing you to answer. You have control of your answer or non-answer. So asking the question is the constitutional violation, just to be clear, just so I understand your position.
Yes, that's not a price or cost that's imposed by Rule 48A.
Okay, and then I want to ask again, because just to be clear, it's a little surprised about your response about lying to the court. So let me make things absolutely crystal clear. You have a crate, and this is a hypothetical case, capital H. Criminal case, district court has said, it's a standard order on Brady disclosures. Government says we've complied, we've turned it over. District court, again, before trial goes, want to make sure you've done everything under Brady, you've given them everything you have, you've asked everyone who would know or have information, you've checked every file. The government says yes, yes, yes. There's nothing else. We've done an open file process in this case. We've given the defendant everything. Third time, district court confirms right before trial, you have done everything Brady requires. Everything has been disclosed. Absolutely, Your Honor. It's now the first day of trial. In the presence of the court, the defendant hands to the defendant's attorney, who then hands to the prosecutor a briefcase filled to overflowing with $20 bills falling out of the seams. It's handed to the prosecutor, who is the U.S. attorney and the Attorney General sitting right there next to her. And the government, upon receipt of that briefcase, submits to the district court a Rule 48 motion to dismiss. And it's 10 pages long, and it has affidavits, and it says there was a Brady violation in this case. So in the presence of the district court, money has exchanged hands. Previous representations about Brady are now being undermined. And your position, as I understood it from your prior answer to me, is that the district court has no choice but to grant that motion to dismiss. And that would be true even if it is unclear whether the district court could prosecute criminal contempt in the court's presence after a case is dismissed.
Yes, but if I may explain my answer, the court can impose sanctions and pursue the Brady violation. It may even be able to pursue the bribery.
I understand. I understand you said that. No, but look, you're saying the district court has to play a part in this, has to finish the bribe and make it effective, has to sully the court's reputation by closing the deal between the two parties. What is your clear authority for that? Because Fokker says on page 743, to be sure, a district court judge is not obliged to accept a proposed decree that on its face and even after government explanation appears to make a mockery of judicial power. So you can't point to Fokker. So what's your clear and undisputable authority that Rule 43A compels dismissal even if it's unclear whether, even if it would, there's a risk that it will strip the court of its criminal contempt and sanctions power once the case is dismissed.
So three things, Judge Millett. The first is I take everyone to agree that that is the situation in the pre-plea situation. I take it even Judge Sullivan agrees with that. So the only question is whether the plea somehow triggers a different regime, and under Rule 48, we don't think it does. It's all bad conduct, to be sure.
Just to be clear, I don't agree that that would be true pre-plea if a bribe was executed in the presence of the court, but go ahead.
I didn't understand anyone to dispute that. But second, I do actually rely on Fokker. First, when the court's talking about the mockery of justice, it's talking about the consent decree context where you are invoking judicial power and an ongoing judicial role. Obviously, you couldn't involve the court in that kind of a mockery. But in any event, here, it has to be a filing
okay,
that
so Rule 43 does allow involving the court in a mockery.
Well, it has to be a filing that on its face makes a mockery. Here, one of the Attorney General's reasons was a policy judgment.
I'm not talking, I'm asking only for an answer to a hypothetical question. That did not on its face make a mockery of justice? My hypothetical? I am not, this is a hypothetical. I am not for a minute suggesting that's what's going on in this case, to be absolutely clear.
No, the motion, and I didn't understand the motion, your hypothetical on its face to be a mockery. The question was what the government's actual motive was that might underlie what it was saying was a Brady violation. The motion on its face seemed fine. It seemed like the kind of thing that could be granted in lots of other cases where there was no evidence of a bribe without any question at all, routinely granted. I took it just to be that the judge has a question about what the real motives are of the prosecutor who's otherwise filed a motion that's found.
No, I will restate the hypothetical. The district court does not wish to be privy and party to closing the deal.
Oh, I'm sorry. I
what
thought
granting the motion will do.
I thought, yes, if the motion just comes in and says, look, we think there's a Brady violation, we want to dismiss, but the court thinks maybe that's not the motive, there was bribery.
You got the hypothetical. It's small. It's clear as rain what's going on. 3 representations about Brady. I'm just trying to I'm trying to make sure, and maybe it's just your position. Sometimes the government has to take hard positions, but there's nothing ambiguous. It's in the presence of the court, and the court wants to protect the integrity of the court and not grant the motion. And the government's position, as I take it, and you can just confirm, yes, is that Rule 43 does not allow the district court to not participate in that activity, to preserve the integrity of the judicial process.
No, I think if you're asking about the consent decree context, it may be different.
I am asking about the hypothetical I gave you, which is a criminal prosecution.
I'm sorry, when you said Rule 43, no, Rule 48
I'm sorry, 48. I'm so sorry, Rule 48. I do apologize. Yes, Rule 48A.
No, I don't think it leaves that rule to the...
We're going to break away from court arguments for a few moments to fulfill our longtime commitment to live House coverage. The court argument continues on cspan.org and will return if it's still going on after this short pro forma session.